Hey everyone, Lee Pacchia here, and you are watching The Business of Law. We're taking a deep dive into patent litigation today. I'm happy to say my guest is David Marcus. He's a reporter with The Deal. Welcome. Good to see you. So you had this really interesting piece hit this week detailing two deals for the sale of a portfolio of intellectual property that you claim are really quite telling of the state of the U.S. patent system. Can you kick us off here by walking us through those two deals and what they mean?
Sure. So both of these deals involve a portfolio of about 6,000 patents that were at one point owned by Nortel, which was essentially Canada's Ma Bell, which went into bankruptcy in 2009. Nortel did not get around to auctioning these patents until 2011, timing that turned out to be fantastic because by then the smartphone wars were white hot. You had Google, Apple, Microsoft, Intel, BlackBerry, everybody competing for this portfolio in an auction that culminated in a frenzied 4 days of bidding at Nortel's counsel, Cleary Gottlieb in New York. A consortium of investors led by Apple that included Microsoft ended up buying the 6,000 patents for $4.5 billion. The members of that consortium, again led by Apple, took about 2,000 patents. Some of them went to Apple, some to Microsoft, some to BlackBerry, some to EMC. Then the rest of the patents, about 4,000, were put in a venture called Rockstar, which was managed by the Nortel sort of IP team. And Rockstar was really hobbled because it had to agree to restrictions placed on it by the DOJ to get the deal through. There's some debate about exactly why Rockstar had some challenges monetizing those patents, but it did. And some of that, a lot of that stemmed from challenges probably within this group of 5 owners. At the beginning of 2014, we get to the start of the second transaction where the Rockstar ownership group seeks to exit the investment, and they end up selling the patents for $900 million to an entity called RPX Corp, which is publicly traded, based in San Francisco. RPX's business is buying patents and patent portfolios and licensing them either to a broad membership base of about 200 companies, or in some circumstances buying select portfolios and then licensing those to a smaller subset of those entities that pay an additional fee. Oh. That's what happened here.
Interesting business. They paid a lot less than the sticker price in 2011.
Well, I think you have to keep a couple of things in mind. First of all, the owners of the Rockstar Consortium, Microsoft et al., skimmed off, took for themselves the most attractive 2,000 patents. So right there, that's value that they feel they received. They also obviously were buying at probably the top of the market. So you buy at the top of the market, you take the assets you think are most valuable. You have 3.5 years of depreciation on the patents. And then you consider sort of the social and political costs to allowing Rockstar to aggressively assert these patents against other tech companies. This probably was not the perfect outcome for the Rockstar members, but it's not like they lost 80% on their initial $4.5 billion investment.
Now, I recommend viewers of this program go check this article out. They can see it on thedeal.com. I personally came away with the impression that the steady flow of patent litigation work that has been out there for the last 5 or 10 years is starting to trail off or maybe plateau. Is that accurate in your view?
I think you can look at this in a couple of ways. One way to look at it is that the smartphone is a technology that brings together a lot of strands of the tech industry. And that means that patent will, becomes very contested in the smartphone. And this is going to happen again and again. It'll happen with cars as they become more driven literally by software technology. It'll probably happen to some extent even with electricity, as you can control the electricity in your house remotely. It'll happen over and over and over. On the other hand, I think the phenomenon of patent litigation that does seem to have crested in maybe 2011 or 2012 was driven by a couple of things. One was the product of a series of decisions by the Court of Appeals for the Federal Circuit, which is the federal appeals court that hears all appeals of patent cases, that expanded the ambit of patent law and made these suits easier to bring. The Supreme Court in the last even 5 years has really reined the CAFC in and sent a very strong message that it wants some of the perceived excesses of this kind of litigation to stop. That instinct was also what drove, to a large extent, the America Invents Act that President Obama signed into law just a couple of months after the signing of the first Nortel deal. You also have, on the part of the companies themselves, perhaps a little more of an awareness that aggressive patent litigation has ancillary costs. It has political costs potentially in Washington. It means that the companies themselves are enmeshed in litigation for many years, which takes away management time and attention, neither of which is good. So I do think a number of factors are combining to perhaps reduce the extreme amount of patent litigation we may have seen in the last decade. And I think there are a couple of other factors, Lee, that are worth noting. First of all, after the tech crash of 2000, there were a lot of companies that were not viable companies that had intellectual property, and they sold those patents, some of them to operating companies, some of them to so-called NPEs or non-practicing entities, or as they're pejoratively called, trolls, who sought to assert those patents against a variety of operating companies. That sort of wave of intellectual property that was just sort of floating around out there, was perceived by the tech industry generally to have real costs. And so a solution like the one RPX offers is very, very appealing to these companies in a way that it didn't seem to be 5 or 10 years ago.
Yeah, I found this quote from Sullivan & Cromwell's Nader Mousavi really, really interesting. Industries are looking for ways to clear significant patent assets without litigating. Assuming that opinion is approaching something close to consensus, what does that mean if you're running a large law firm and you had this well of work? I mean, back in the legal recession, going back to 2008, 2009, 2010, law firm leaders could always hang their hat on this area of BigLaw as a profit center, as an area of growth. Well, are those days coming to an end?
I think they may be, at least temporarily. If you take the really long view, patent has always waxed and waned in importance.
So it's like bankruptcy work, comes and goes.
Yes. I mean, if you take a really long view, 100, 150 years, and obviously patent dates back to the beginnings of the United States, patent was used very aggressively in the era when the railroads were tech startups. In the middle part of the 20th century was viewed with great skepticism. And there did seem to be less patent litigation, but patent became very important again in the era when there was tremendous innovation in semiconductors in the 70s and 80s, and ultimately those major companies realized that they could not litigate one another into oblivion, that ultimately they had to license. So I think you'll continue to see patent litigation, in part because these are global companies and you can have patent disputes all over the world. I think you one may see it may be easier to get suits brought by certain kinds of entities, non-practicing entities, dismissed because of changes in legal regime and perhaps greater judicial skepticism. I think on balance that's good for American industry. It may not be fabulous for the law firms that did that work, but patent licensing will, I think, continue to be important. And companies, will have to look out 5 or 10 years and try and anticipate where various industries are going to converge and how that's going to affect the intellectual property they have and the intellectual property they're going to need.
David, really interesting stuff. Great article. I recommend you guys go check it out. Thanks for stopping by and talking to us.
No, thanks for having me on, Lee.
That's David Marcus, reporter with The Deal. If you'd like to see more of the stuff we're working on, be sure to go check us out at mimesiswebtv.com. We also have a YouTube channel and a Twitter handle under the same name. I'm Lee Pacchia. Thanks for watching.